One thing I really hate is having to cover the same content over and over again. But when the myths just won't die, I just don't feel right ignoring that. Especially when the haters of free speech get their platform on a website like Slate. It's funny that Slate has the motto of an ongoing science experiment, because if they have their way, as they say in this article, websites like Slate and pretty much all of the others will lose their freedom to experiment in the new media. You know it's fail right from the title. Tech companies get a free pass on moderating content. It's time to change that. You know they're talking about Title 47, Section 230 of the U.S. Code, which I've covered in the past. Section 230 takes common law conduit protection and applies them online. Basically, websites and other providers of internet services cannot be held responsible for the actions of users, even when those users are using their services. So basically, if someone drives a Ford F-150 into a crowd of people, Ford isn't responsible. If the crowd was at a shopping mall, the mall isn't responsible. The only responsible person is the driver. By the same token, if a user of a website uses that website to engage in illegal activity, the user is culpable, not the website. That's what Section 230 says. We've already seen the chilling effects of denying Section 230 protections when the Backpage website was shut down on allegations of sex trafficking, which led to the passage of Sesta Fosta and the subsequent yanking of the personal section on Craigslist. Now, law enforcement is saying that it's become a lot harder to investigate pimps and sex traffickers because a valuable tool was taken away. But get rid of Section 230, and you not only infringe on freedom of speech, you impede law enforcement investigation as well. They start off in their very first paragraph lying about the history of Section 230. In 1996, Congress faced a challenge. Lawmakers wanted the internet to be open and free, but they also knew that that very openness could allow for noxious activity. Federal agencies could not tackle the problem alone. They would need help from tech companies. Well, you can see what the problem with this is in the very next sentence. It was passed as part of the Communications Decency Act. This was an attempt by Congress to censor porn on the internet. They put in Section 230 so they wouldn't completely kill the technology with their censoring activities. And like I said, it was really just a codification of conduit protections that already existed in MeatSpace. So, question right off the bat, if this author is on the level, why did she have to lie about why it was passed? Although the purpose of Section 230 was clear, the statute's language was not. Section 230C1 did not explicitly condition the protection on responsible content moderation practices. Oh my god, the lies just get bigger and bigger. Let me quote you the relevant passage from Section 230. No provider or user of an interactive computer service shall be held liable on account of any action voluntarily taken in good faith to restrict access to or availability of material that the provider or user considers to be obscene, lewd, lascivious, filthy, excessively violent, harassing, or otherwise objectionable, whether or not such material is constitutionally protected, or any action taken to enable or make available to information content providers or others the technical means to restrict access to material described in paragraph 1. That was in paragraph C2. So this puts lie to the claim that Section 230 is only supposed to apply to platforms, not publishers, and that once you start moderating, you lose the protections. But did you see how she snuck in the lie? She said that paragraph C1 didn't include this protection. No, because it was included in C2. This was an outright lie. Over the past 20 years, courts have massively overextended Section 230's legal shield. Platforms have been protected from liability no matter how irresponsible or worse their conduct, and no matter how grave the harm inflicted. For instance, Section 230 has been extended to protect sites whose business is revenge porn, whose operators choose to post defamation, and whose role is getting a cut of illegal gun sales. That is not an overextension. That is exactly the kind of protection Section 230 was there to protect to begin with. If someone uploads something illegal like revenge porn, that user is the one liable, not the website. If you follow the link to her claim about the illegal gun sales, you'd see it was about people suing MGM for the Mandalay Bay shooting, like it was their fault somehow. They actually blamed MGM and gun websites for the mass shooting. This is the kind of person we're dealing with here. Section 230 is not a clear win for free speech or equal opportunity, as Mary Anne Franks has argued for in her important new book, The Cult of the Constitution. Oh, doesn't that just fill you with confidence about this woman? By the way, Mary Anne Franks is a huge anti-pornography lobbyist who's tried numerous times to get legislation passed banning or at least severely restricting pornography, even though it's completely protected by the First Amendment. So yeah, you see who this author is relying on for information. An overbroad interpretation of Section 230 has been costly to equal protection. The benefit Section 230's immunity has enabled likely could have been secured at a lesser price. The benefits are freedom of speech, and they cannot be secured at any lesser price, whatever you consider the price to be. As John Perry Barlow said, we cannot separate the air that chokes from the air upon which wings beat. We need legal reform to ensure that platforms wield their power responsibly. We should keep Section 230's legal shield, but return it to its original purpose. One way to do that would be to exclude bad actors from the immunity. But who decides who is a bad actor? This is always the problem with this sort of government intrusion. This stupid woman is thinking about the people she doesn't like being declared the bad actors, but like all authoritarians, she doesn't seem to want to consider what would happen when people who disagree with her get into power. What if some fundies take power and decide that atheists and evolutionists are bad actors? What if some neo-Nazis take power and decide that Jews are bad actors? History tells us that not only can something along those lines happen, sooner or later it will. This is always the case when government gets some new kind of power. Free speech scholar Jeffrey Stone, for instance, suggests denying the immunity to online service providers that deliberately leave up unambiguously lawful content that clearly creates a serious harm to others. Did you spot the language there? Deliberately leaving up content. Leaving it up is passive. They may not even be aware of it, especially if they're a site run by a small group but have a lot of users, and they're not in a position to police every post. They can only act on what has been pointed out to them by law enforcement officers with a legitimate warrant. So what he's talking about is exactly the same thing we're seeing with Article 13 in the EU. This would mandate either incredibly large staffs to go through the content, or paying for or developing automated filters, which means again that the little guy will lose out. This won't be an impediment to Facebook or YouTube. In fact, they love it because they can cut down the competition. This is something else that's always the case with government regulation. The little guy pays the price while the big corporations keep doing whatever they want. A variant on this theme would deny the legal shield to cases involving platforms that have solicited or induced unlawful content. But they are already denied that shield. They can be charged with conspiracy or with interfering with an investigation or whatever, but you have to prove it. You can't just whine loudly and expect them to be liable. They have the same rights to a fair trial and the presumption of innocence as everybody else. She makes a big deal about the Grindr case, which I've already covered, so I won't go into it again, other than to point out that Grindr was actually a big help in tracking down the perpetrator and providing evidence against him. She ends with a classic politician's fallacy. Doing nothing is a choice. It says that we are willing to tolerate harms that people experience, especially women and minorities, so that platforms can continue to make money from their irresponsibility or far worse. You cannot hold someone liable or criminally culpable for doing nothing. With a very few exceptions such as negligence, which don't apply here, every criminal act requires mens rea, the guilty mind. We've also talked about the horrors that can happen when that requirement is denied. The anti-Section 230 people, the haters of free speech and individual autonomy online, would bring every single one of these horrors into the online world. So thanks for watching, and I hope you enjoyed this video. If you did, please like this video and subscribe to this channel, and also go to donate.bogosity.tv, where you'll find several ways to support this channel, which is becoming more and more important in this age of demonetization and shadow banning. You can donate with PayPal or crypto, become a regular supporter on Patreon or Subscribestar, or watch my content on BitTubers.com, which is always monetized and never censored. Until next time, stay strong and be free.